in that he demanded 15 million, or maybe let me put it differently for it to be understood. As Nomnubo was submitting these claims, which we said were 44, 9 of them, which were for children with cerebral palsy, were all 15 million rand. And it was very suspicious. And we believe it indicates a lot of cut and paste, where you sue for one child, then you just run around the village looking for some more children, and you submit the same claim, you just change the names. We think that's what attorneys were doing. This is so because when people claim, they claim for things like future medical care, loss of earnings, loss of amenities of life, etc. They can never be identical for each and every person. But in this case, the 9 were identical. That's why we're very suspicious. Between 2010 and 2016, medical legal claims increased from 46 to 529 in the Mthatha High Court alone. There is evidence of collusion between attorneys, touts, unfortunately nurses and doctors in both public and private health care. In some instances, nurses stole the medical records and illegally handed them over to attorneys. I was listening this morning to one of the TV stations when a representative of DINOSA was interviewed, and he mentioned something like this, that if their members' action need to be taken, I want to confirm to him that that was actually a finding. And how does it occur? The moment lawyers hand over a claim which they know is fraudulent, they immediately send somebody to steal the file, so that the health sector, the Department of Health, cannot prove that such negligence never occurred. And in all cases, if a file is lost, the judges rule in favor of the claim, of the claimant, because the government is not able to prove anything. And so these files got stolen. Out of experience, the 70 million rand claim I'm speaking about, I suspected that something like that was going to happen when I saw it. And the MEC in Limpopo was then Dr. Popira Matuba, the present premier. I said, drop everything you are doing, rush to Letaba Hospital, grab that file, because we know within short space of time, it will be gone. And that's how we found that no circumcision was performed. If that file was performed, we did not grab it, the judge was going to agree that we performed a medical circumcision and botched it, and so the patient will have to be paid. So this stealing of files is quite devastating to the healthcare system, and it's very painful that is done by health workers. Now, after this file is stolen, the attorneys will then apply through PAEA, Promotion for Access to Information Act, for the same record that they know they are illegally in possession of. In other words, you steal a file, keep it in your office, and go to apply via PAEA and say the hospital must give you the file, when you know very well that you have already stolen it. And so naturally, such a record will not be found. The hospital will search and search, go to the archives, search for many weeks on end. They will never find the file because it's in the possession of the lawyer. Then the lawyer will come and claim fees from the department for failing to produce records. And this was also found to be very prevalent. Unfortunately, very unfortunately, there was also collusion involving some officials in the office of a state attorney, whereby out-of-court settlements for hefty sums were entered into without the mandate or even the knowledge of the department. Remember, the people who are being sued here is the Department of Health. The state attorney are just legal representatives of government. But many of them, I mean, in some instances, they entered into hefty sums of out-of-court settlement without the department knowing anything about it, even in cases where the department would have been able to defend. Litigating attorneys will even sue for one case in 2 different courts. I'm sure you might be aware that our courts do not have an integrated information system. If the state in the form of NPA doesn't pick this up, it will happen that this one case of one patient is appearing in 2 different courts at the same time, or perhaps at slightly different times. A variation of this situation is where 2 different lawyers will claim for the same patient using identical details, but they submit them to different courts. Notably, whereas the patient is one person, the 2 attorneys will claim vastly different amounts. In the case of this patient, which you can't name, one attorney was claiming 7.5 million, and the other was claiming 25 million. But the condition for which they was claiming was the same. And you can see the difference between 7.5 million and 25 million. This clearly indicates that quite a number of claims were just arbitrary. You just sit there and write an amount arbitrarily without anything medically or legally informing you. Now, after these findings were made in the Eastern Cape, the National Health Council, which you know, is a National Health Council is what in other departments they call a MINMEC, where the MECs and the minister come together. But in the case of health, it is called National Health Council, not the MINMEC, because it also involved other other organs of state and other spheres of government, like it also involved the South African Military Health Services, but it also involves SAGA representatives. And unlike other MINMECs, it is actually a statutory body. The decisions which are taken there are statutorily, are actually statutory. So this council decided, after the SIU gave these preliminary findings about Eastern Cape, that all provinces need to be investigated in a similar manner. Hence, the SIU obtained Proclamation R74 of 2022 from the President of the Republic to conduct investigations all over. On the 29th of July this year, that's last month, the SIU briefed the department about progress in this regard. So I'll just summarize the progress. We are seeing progress because they are still very far from finishing. We just thought because it takes a long time, people believe nothing is happening. Advocate Mutibi, like yesterday, the claims that were made all over the media about the late Babita Diokren, that nothing is happening. I'm happy to hear that during the memorial, during the evening, you actually give details of how far you are. We are doing the same here because people might believe nothing has been happening about medical legal claims. I also heard sometimes members of parliament also making similar statements. So I just want to summarize. It's in the form of a table. Firstly, let's start with Eastern Cape. Up to so far, 2,500 medical legal claims that are valued at 22.3 billion have been submitted. And I repeat, the 22.3 billion is not what Eastern Cape has paid. It's what the lawyers have submitted. That we want money to, each one of them saying, I want this much. When you add, it's 22 billion. So the number of claims are 2,500. Now the SIU currently, out of these 2,500, is currently investigating 197 claims, which are valued at 2.3 billion. You can see it's still a tip of the iceberg. Out of 2,500 claims, they are still at 197 because it takes a long time. But the total amount that Eastern Cape has already paid, calculated from 2015-16 to 2020-21 financial year, that means within that 5 years, Eastern Cape has paid 3 billion 3,039,951,634.08. This is the amount that Eastern Cape has paid up to so far. Now the SIU, out of this 197 cases they are investigating, which are worth 3.8 billion, they've already completed 89, and these are to the value of 1.2 billion. So at the moment, they are still left with 108 out of this total they've already started investigating. And those 108 will be worth 2.6 billion. Now, what are the summaries of irregularities, specifically for Eastern Cape? We have mentioned them in general terms, but what is the summary in these cases that they've already completed? The SIU has finalized, that's number one, irregularity, has finalized its investigation regarding 23 letters of demands, whereby lawyers were demanding 298 million from the Department of Health. 15 of these 23 letters of demand, to the value of 271,800,000, were fraudulent because the claimants told the SIU during the investigation that they have never visited any of the health facilities that were being litigated against. And indeed, when the SIU went to the hospitals, they found no records of such patients, confirming the statement by the patients that I never went to that hospital, I don't know what you're talking about. Notably, all these letters were submitted by a single law firm, but this particular law firm were unable to name it because they've not yet been charged in a court of law. So we'll have to withhold the name of that law firm, unfortunately. Number two, these fraudulent claims were successfully removed from the contingency liability of the Eastern Cape, because if they are fraudulent, then they can no longer appear on contingent liability. The significance of this is that when they audit the general audit books, they also calculate the contingent liability, and they issue the statement on the basis of contingent liability and start worrying and give that province a very negative overview, because they all know that the claims, the auditor general won't know that this is out of fraudulent claims, so they have to be removed. Number three, there are 35 additional matters valued at 600 million rand currently under investigation, initiated by the non-Nguba attorneys, which we have already named, in which no trusts were registered as per the court's orders. The SIU has made 45 referrals, that's number 4, 45 referrals of attorneys to the National Prosecuting Authority, amounting to 279.5 million for consideration of criminal charges related to fraud, theft, embezzlement of trust funds, and contempt of court against certain legal firms. This includes the non-Nguba attorneys. Again, we are unable to name these certain legal firms because they have not yet appeared in court. The same attorneys were also referred to the Legal Practice Council, LPC, which you all know is a professional representative of attorneys. These matters have been referred to them for violation of the Code of Conduct of Legal Practitioners and the Legal Practitioners Fidelity Fund to consider reimbursing claimants whose funds were embezzled by the legal representative. I need to explain this. There is an institution called Legal Practitioners Fidelity Fund, where lawyers deposit money in case there is a suit against them. So when a patient has been cheated in the manner we're explaining here, because the lawyer will have already embezzled those funds, the Fidelity Fund will pay them so that they don't suffer damage caused by their own lawyer. So these cases have been referred by the SIU 5, the SIU has identified numerous cases in the Eastern Cape where the living conditions of the claimants and their children remain appalling, despite having received compensation from the department, which money has been paid to their lawyers. We are counting millions here that the department already paid in the Eastern Cape. But the patients for which they were claiming are living in abject poverty because they never received a cent. Many of these claimants are unemployed and rely on social grants from SASSA for their livelihood, despite millions having been deposited into their lawyers' account. Some households are constrained into a single room or a small rondavel without appropriate railing or ramps to assist disabled children, resulting in inadequate living conditions and insufficient caregiving, despite the fact that in the claims, money has been paid for this type of facilities. This means when the lawyer claims in court, he'll say, "My honor, I also claim so much money because this person is on a wheelchair, they need to access the house, they need to be railings and all that." But when you go there, there's no such. Whereas the judges agreed that that money be paid by the state, and the state had indeed paid the money, but the poor patient received nothing. Furthermore, the SIU found that these children continue to place a burden on the already strained public healthcare system, whereas in the claims in court, the lawyer cited future medical care based on fees charged in private hospitals. In other words, they'll say this child must get the best care in a private hospital, and we demand so much, and that money has been paid, but they will never see the inside of any private hospital. They will still come to state hospitals. One notable instance, this is the last irregularity in the Eastern Cape. One notable instance involves cases where the department paid 373,850,748 rand 04 to Ngonquba, the attorneys have mentioned, for 22 claims between 2018 and 2021. However, several years later, an inspection by the SIU revealed that none of the claimants had trust accounts registered in their names as ordered by the courts, and their living conditions were found to be deplorable and impoverished. This means that Ngonquba attorneys have pocketed all the money for themselves, and this matter is already before the courts. I want to explain because I hope members of the public are listening. When a lawyer sues the state on your behalf, the money so paid doesn't go directly to the patient. It goes to the trust account of the attorneys. The court will then rule that a trust account be opened by the attorneys on behalf of the patient. And this is what Ngonquba attorneys never did, meaning they keep the money for themselves. They are not the only legal firm that does so. Quite a number of them do. But as I said, we are unable to name them. Let's go to the Free State. 417 medical legal claims have been submitted to the tune of 4.9 billion. 52 claims valued at 400 million are currently under investigation by the SIU. The Free State, over a period of 5 years, from 2016-2020 to 2015-16 to 2020-21, the Free State has paid 95,607,862 rand and 16 cents. Number of and value of cases finalized by the SIU is 30. 30 cases have been finalized to the tune of 280 million. A number of cases still under investigation by SIU, 22 cases which are worth 120 million. The summary of findings in the Free State: number one, the SIU has identified a matter where the claim was valued at 7.5 million, in which the lawyers went against the medical advice of their own expert, who advised them that there was no negligence on the part of the department. When the SIU confronts the lawyer, he then immediately withdrew the case. This means the lawyer went to his own medical expert, hoping to get the report to sue the state. And the medical expert wrote and said there's nothing to sue for. But the lawyer pushed that medical advice for his own expert and went to sue. But when the SIU confronted him, he immediately withdrew the case. Again, in the Free State, non-Nuba attorneys were found to be practicing without a Fidelity Fund certificate as required by law. This matter has been referred to NPA. So non-Nuba attorneys is not only in Eastern Cape, they are also found in the Free State. The SIU has made 17 referrals to the Legal Practice Council against 3 law firms, including non-Nuba, for misconduct related to touting for work, which is forbidden by law. The value of these referrals is approximately 78 million rand. Unfortunately, we are not able to name the other legal firms because there were 3. We are only naming non-Nuba again because the others have not yet been charged. The last finding in the Free State, the theft of medical records has been discovered in the Free State too, along with 2 other attorneys without withholding funds intended for claimants. It was found that in most instances, the hospital did not have these medical records. The problem involved 2 specific hospitals in the province. In one case, where a settlement for general damages was made, the court did not require the establishment of a trust. Instead, 6 million rand was paid into the claimant's attorney's account. The attorney firm paid the claimant 250,000 rand initially, and then 10,000 monthly. This irregularity is under further investigation by the SIU. As can be seen, this law firm is making undue benefits from the interest of the money that belongs to the patient. Let me go to Gauteng, which is the biggest up to so far, more than even Eastern Cape. 2,450 medical legal claims have been submitted in Gauteng to the value of 24,445,550,786 rand. The number and value of cases currently under investigation by SIU, out of these 2,450, SIU is investigating 611 cases, valued at 4.1 billion. And the total amount of money paid by Gauteng over the 5 years, from 2015-16 to 2020-21, is 1.001 billion, to save time. The number of value of cases finalized by the SIU out of these 611, which are under their investigation, they finalized 58 cases valued at 66,015,000. And number and value of cases unfinalized is still 2,392 cases unfinalized, to the tune of 23.7 billion. Summary of electoralities in Gauteng. The SIU identified 40 matters involving claims submitted to the value of 496,650,000. 19 out of these 40 claims are on behalf of children who are actually deceased, but the lawyers continued with the claims. 2, I'm sure you'll understand why this is important. Somebody is late, but you continue with the claim, which might have started when they were still alive, but you are continuing. In the claim, you are claiming for future medical care when the person is already gone. You are claiming for loss of amenities of life. You are also claiming for loss of future income. 2 of the 40 are actually employed, whereas the lawyers have claimed for loss of earnings. 1 child actually had no cerebral palsy at all, whereas the lawyers were claiming for this condition. 9 claimant attorneys withdrew when they realized that the SIU was investigating The value of this case, the value of their claims which they withdraw is 149,304,325. One case was struck off the roll, obviously because it had no merit. In all these instances of wrongdoing, the SIU will refer implicated attorneys and officials to the NPA for criminal investigation or charges, and the LPC, the Legal Practice Council. Let's go to the KZN, the third province. Number of claims 2,440, valued at 29 billion. I made a mistake. I said this Gauteng, which is the biggest. The kingdom is actually the biggest. 29,140,032. 29,140,032,315 rand 42 cents. The number and value of cases currently under investigation. Out of these 2,440, the SIU is investigating 713 to the tune of 8.7 billion. Total amount paid by KZN up to so far for the 5 years, reminding you 5 years is 2015-16 to 2020-21, is 1.3 billion already paid. Number and value of cases finalized by SIU out of this 713 they are busy with is 107 matters finalized, and the value is 2.4 billion. Number and value of cases unfinalized is still 1,420 to the tune of 18 billion. Summary of irregularities identified in KZN. Out of the 107 matters finalized, 76 relate to instances where claimants are actually deceased, and the value of 1.5 billion. This money has been removed from the contingent liability of KZN. One attorney was found to have submitted a claim to the value of 16 million rand after the death of the child. The child died first, and the attorney submitted a claim of 16 million rand. Significantly in court, the lawyer was claiming for future medical care based on private hospital rates and loss of amenities of life. This one will also be referred for criminal prosecution. Number 3, irregularity in KZN. The SIU has made 4 referrals to NPA and 3 to the Legal Practice Council against attorneys and private individuals who were found in possession of stolen medical records. This issue of stealing medical records. So these people have been caught and referred to. Now, all in KZN, all in all, 2,416,284,800 rand has been saved. It has been prevented by the actions of SIU. I'm sure you may just notice that this amount, just for KZN, is bigger than VBS amount. I'm saying so because in VBS, you see headlines and all that. But here is some heist in one province bigger than VBS. The difference is that in VBS, victims were poor, women, funeral societies, etc. In this case, it is the state that is paying, but all of us in this room are victims because this is public money. So this money, 2.4 billion, has been saved. If the SIU didn't come in, this money will have been lost. Let me go to Mpumalanga. Mpumalanga, 419 cases submitted to the tune of 6.4 billion. A number of value of cases currently under investigation is 902 to the tune of 10 billion. Total amount paid by Mpumalanga is still 139. I want to explain. Mpumalanga is still really at the beginning of the claim, so there are not even irregularities found. They were the province that is lagging behind because the SIU might have gone to it much later. So let me jump to Limpopo. Limpopo, 1,600 medical legal claims were submitted, and they are valued at 14 billion. Currently, out of this 1,600 claims, the SIU is investigating 303 cases involved, which are valued at 5.2 billion. Total amount paid by the department up to so far is 248,390,884 and 66 cents. That has been paid by the, that has been paid by Limpopo during that period of 2015, 16, 2020, 2021. Number and value of cases finalized by SIU, they finalized 63 cases worth 139 million, and the number and value of cases unfinalized, meaning still under investigation, 698, which are valued at 2.7 billion. Summary of irregularities or wrongdoing found in Limpopo. Number one, the SIU identified 26 matters to the value of 657,291,825, in which the claimants were confirmed to be deceased. But the lawyers continued with the claims, in which they are also citing future medical care, loss of income, loss of amenities of life, as they've done in other provinces. These cases have been referred to NPA for criminal persecution and the Legal Practice Council for professional misconduct by the involved lawyers. In another matter, that's number 2, irregularity Limpopo, the department paid 120,000 rand for the claims into accounts of the attorney's trust. Amazingly, the attorney kept the money. It's very little, but we are talking about the moral value of it. This happened in 2016, but the attorney did not release that money to the claimant. When the SIU have authorized investigating, the attorney got scared and even paid double of the amount he was supposed to pay. I don't know whether he thought maybe the sentence would be lesser, but he didn't have to double the amount, but he did. The amount of 657,291,824 cited above will be removed from the province's contingent liability. Limpopo is 657 million less liable than the lawyers had claimed up to so far, but you can see the SIU is still at the beginning. Northern Cape, 114 medical legal claims to the tune of 1.5 billion have been submitted. Number and value of cases currently under investigation, 20 to the tune of 558 million. Total amount that has been paid by Northern Cape is 1.4 billion, which is very, very high compared to the size of the province. Number and value of cases finalized. The SIU has finalized only one case worth 23 million, and they are still left with 19. I mean, out of those which they are investigating, 19 worth 535 million. Summary of irregularities in Northern Cape. The SIU investigation uncovered a case where 31 million rand was deposited into the attorney's account to pay the claimant directly. However, the lawyer did not open the trust account as directed by the court order, which resulted in them keeping the money and earning back interest. This matter has also been referred to NPA and LPC. This is Northern Cape. In one instance, a lawyer was paid 18.7 million by the court. This was an out-of-court settlement. In other words, the lawyer claimed a certain amount of money, but in out-of-court settlement, which was approved by the court, the lawyer got 8.7 million, but is paying the claimant only 6,000 rand per annum. I mean per month, sorry. Only 6,000 rand per month for the past 18 months. There's no indication that the lawyer was going to pay any other amount if the SIU did not intervene. This case has been referred to the LPFF, the fund I've spoken about, to reimburse the poor patients. And let me just summarize it. The lawyer received 18.7 million rand. But over an 18-month period until the SIU intervened, the poor patient was getting only 6,000 rand. If you calculate it, it was going to be 72,000 per annum. And this poor patient was only going to reach 1 million after 15 years, when 18.7 million in their name has been issued by a court of law. The SIU further identified 4 matters to the value of 169,400,000, all submitted by one attorney. The patients were interviewed and denied that they ever signed a power of attorney or instructed any attorney to lodge claims against the department on their behalf. 169 million, 4 matters where patients know nothing about, but we can't name the attorney again. This matter is being referred to the NPA and LPC. Northwest, 230 claims submitted to the tune of 1.5 million. Currently, 32 cases under investigation to the tune of 222 million, 222 million. Total amount paid by Northwest over the period 2015-16, 2020-21 is 122,491,200 is the lowest up to so far. Number and value of cases finalized, 12 to the tune of 32 million. Number of value of cases unfinalized, which are still under investigation by SIU, is 20 cases worth 190 million. A summary of findings in Northwest. The SIU found that 3 cases where 45 million rand was not deposited into the trust account for patients as required by the court. 3 cases worth 45 million was not deposited into the trust account for patients as required by the court. Instead, the money was placed into the attorney's trust accounts since December 2018, accruing interest rather than establishing a trust account on behalf of the patient. This matter would also be referred to NPA and LPC, NPA and NPC. Secondly, in Northwest, SIU discovered a case in which a claimant's attorney received 14,450,000 and only paid the patient 370,000. This money was deposited into the attorney's account in February 2021, but the attorney only paid the patient in May 2022. That means after 1 year of receiving 14.5 million, after 1 year the patient received only 370,000. The investigation revealed that the attorneys acted fraudulently and in contempt of court. Again, we are unable to name the attorney, not yet charged. The attorney is not yet charged. And the matter has been referred to NPA and LPC. Western Cape, this will be the last province. Mercifully, the last province. Number of cases submitted, 409 claimants to the value of 2,852,588 rand, 588,055 rand and 99 cents. The number and value of cases currently under investigation, preliminary assessment of raw data, database of claims provided by the Office of the State Attorney, so it's still the beginning. But the total amount paid by Western Cape from 2015-16 is 273,248,535 rand and 91 cents. Number and value of cases finalized, I've already talked about preliminary assessment. Summary of irregularities in the Eastern Cape. The Eastern Cape up to so far, sorry, my apologies. Maybe let me take some water. Yes, we are on Western Cape, the last province. In the Western Cape, they were hit by only one attorney. up to so far. I'm talking about the irregularities found, because the others could be found because it's still preliminary assessment. But what has been found and finalized is one case. It's one lawyer. The SIU identified 33 fraudulent birth injury claims, that means cerebral palsy, in the contingent liability register to the value of 409 million rand. These cases include allegations of fraudulent medical negligence claims, and they were submitted by one legal firm, which is known, as we have said, on behalf of these various patients. Fortunately, none of the 409 million rand has been paid, and it will be removed from the contingent liability. So, in total, from 2015-16, 2020-21, all the 9 provinces have paid 7,749 million 4,478 rand and 45 cents. I'm repeating this because this morning I heard all over the media houses that provinces have paid 28 billion or 24 billion. I think we somehow confusing the claims to the total amount of paid, and I'm repeating. All 9 provinces added together between 2015-16 to 2020-21 paid 7,754,478 rand and 45 cents. Now, so far, in the matters finalized by SIU, and as you heard the figures, it's still the tip of the iceberg because they are still at the beginning of the investigation. Regardless of the fact that they are already at the beginning, the SIU has saved the state the sum of 3,104,684,800 rand. This money would have been paid if the SIU did not come in. It has been saved for the department. And obviously you can see these savings are going to increase dramatically as investigation happens. So in conclusion, the relationship between the department and SIU in the fight against corruption will not only be limited to the medical legal investigation. We planned on the foundation of corruption. Now I want to assure you that that's not going to be allowed. We are already working together with the Health Sector Anti-Corruption Forum. That includes SIU. We're not going to allow any corruption just to happen under our noses. We've seen enough. There are naysayers that investigation by institutions like SIU are just for public relations exercise and are meant to yield no results. This was said by a prominent South African in May this year, just 2 weeks, 10 days before election, after the Department of Home Affairs called the SIU to raid the refugee reception centers, in which many of you in the media attended. And this was done after a tip-off by a whistleblower. And somebody said, we know that these things are just happening for public relations. Now I can assure you today, the results of those raids in the refugee centers will come out in the same way as the SIU started investigating medical legal in 2017, and the results are only coming now. You know, the wheels of justice grind very slowly, but when they start grinding, they grind exceedingly fine, and this is going to happen. So those naysayers who in May will say, no, this is just public relations before elections and all that, must know that the SIU, we already know some preliminary results, but today is not their day. We wish to take this opportunity, and I'm asking the media to listen carefully because I want you to come and help in this case. We wish to take this opportunity to make an offer to lawyers who might have knowingly submitted claims that are fraudulent, as happened, to come and withdraw them within 2 weeks, and there will be no consequences. If you are a lawyer out there, you have submitted a claim in the category of fraud, please come and withdraw them. Nothing will happen to you because you'll have gone. By the way, we didn't give you the figures of lawyers who withdraw in the Eastern Cape when they had that SIU is in. They came to withdraw. So we are calling on lawyers, please come and withdraw, and we are promising you publicly nothing will happen. And we are giving you 2 weeks. But failure to withdraw within 2 weeks will mean that the offer will lapse and the SIU will strike. Thank you very much.